Good morning, Your Honour. Thank you, Your Honour. This is, I appear for the applicant in this matter, and this is my application for directions. Has Your Honour had a chance to read the party skeletons and the application schedule? I'm very grateful, Your Honour, that will save me a lot of time. Perhaps just one housekeeping matter to start with. The reason there are a number of people in the court is this is a directions hearing, but there's also a representative of the transferee in the court, Mr. Bastani, who's a registered practitioner for the DIC court, and he may address Your Honour on a couple of issues.
He's not represented by that direct.
He's the legal representative of the transferee sitting behind me. The DFSA have raised a couple of issues that are relevant to the transferee alone, and with the court's permission, Mr. Bastani will address you on those narrow issues. Mr. My phone is on the left. I've had a conversation with Mr. Lake as to the proposed running order, which, with your permission, Your Honour, I'd like to run past you. I was going to go through some of the background, but if Your Honour has read the document, I can save time. Your Honour will have seen from the DFSA skeleton that they've raised what we would describe as a threshold issue in relation to the requirements of the scheme report under Article 111 of the regulatory law, and in particular the role of the scheme report provider. Because that is such a key issue in our submission, the intention would be for my colleague, Mr. Shanahan, to address you on that issue, and then, if necessary, depending on the outcome of that discussion, I will address you on the remainder of the further directions sought in the application, because depending on the outcome of that discussion, those directions may or may not be necessary. I've had a discussion with my learned friend Mr. Lake, and I don't think he objects to that manner of proceeding is acceptable to the court.
In the course of the hearing, I shall want to hear on all matters that are raised by the DFSA, and it doesn't matter too much in which order we take them, say for this primary question which you want to take first, but we must have all those identified.
Yes, Your Honour.
Now, it would be helpful then if I could first have identified this threshold point, take it back to the past, to the skeleton, where I want to just sharpen up my focus on at this point to get some early appreciation of the issues, and then I'll hear from your side, and I'll hear from Mr. Lake, and if the transferee wants to make any submissions on this aspect, he may not. I'll hear from the representative.
I'm grateful, Your Honour. The threshold issue that I described was raised in the DFSA skeleton, but perhaps I can hand over to my colleague, Mr. Shanahan, who's going to address you on that specific issue.
Yeah, Your Honour, my name is Matthew Shanahan. I appear for the applicant. I'm also an employee of Clifford Charles LP. The respondent, DFSA's bundle and skeleton was received yesterday. We've had 24 hours to consider it and prepare submissions. But for that purpose, we have produced a supplemental bundle, which we'd like to hand up if possible. The DFSA and the transferees also have received a copy of that additional supplemental bundle. Your Honour, I'll start by saying it's been some years since I've been on my feet, so forgive me if I'm a bit rusty. Thank you very much. Because this is only the second Part 9 transfer scheme to reach the DIC courts, there was one in 2009, which was a simple intra-group transfer. This transaction has been a bit of a learning curve, both for the applicant and, I may say so, for the DFSA. and it's been quite an iterative process. The cooperation between the applicant and the DFSA has been very good. However, invariably, some differences have arisen. So we're dealing with a blank canvas of sorts here. And the key issue of difference is the status or the status of the scheme report provider under Part 9 of the regulatory law. This appears to be the key threshold question for this directions hearing. So in the course of my submissions, I'll refer to the issue generally as the Part 31 issue. In other words, whether the scheme report provider should be subject to Part 31. And in respect to the Part 9 regime, which mandates the banking transfer scheme, I'll refer to that generically as Part 9. I estimate I'll need to address you on Part 31 issue for approximately 40 minutes. Would it assist the court if I give a brief outline of the Part 9 regime? Your Honour, the Part 9 regime is effectively made up of three different aspects. First of all, there's Part 9 of the Regulatory Law 2004. The Regulatory Law 2004 is the foundation law, as it were, for the DIFC regulator, the DFSA. It sets out its functions and powers, amongst other things. And in Part 9 contains what is described as the control of financial services transfers. The relevant part, the law sets out requirements for what are termed financial services business transfer schemes. And under Part 9, a scheme is a transfer scheme if the whole or part of a business carried on through an establishment in the DIFC by an authorised firm, and that would be banks and insurers and others, is to be transferred to another body, and the business to be transferred consists in whole or in part of financial services business. So as you can see, it has a very broad application.
It might be handy if I had the provisions over in front of me. And I think
I could take your Honour to tab 6, tab 6 of the application bundle. At page, it starts at page 20 of that bundle.
yeah, I'll just have that open so that I can answer the
So the section I quoted was section, articles rather, 107A, which describes what a transfer scheme is. But the overriding principle of Part 9, and that's found at Article 106, is that no financial services business transfer scheme is to have effect unless an order has been made in relation to it under Article 108. And Article 108 sets out that an order must be sought from the court approving or sanctioning a transfer scheme prior to it being effective. Now, in terms of the history of Part 9, essentially it's based on the UK Financial Services and Markets Act equivalent. That's in Part 7 of what I shall refer to as business. Until recent changes in the UK to Part 7, the two regimes were largely identical. The key difference was that in the United Kingdom, the regime is only mandatory for insurance transfer schemes. However, in the DIC, until February 2015, it was mandatory for any form of business, financial services transfer scheme. As I mentioned, the regime is very broad, potentially applies to any transfer of the whole or part of a financial services business in the DIC, and it requires a court-sanctioned order. It has been in place since 2004. Other than the one previous transfer scheme, which was in 2009, it hasn't really been used. for a number of reasons, which I won't make submissions on. However, in February 2015, the DFSA created rules in Chapter 12 of its General Rulebook module, the effect of which is to limit the scope of Part 9 to insurance, banking, and fund transfer schemes. So all these types of transfer schemes are now mandatory, but all other transfer schemes, for example, a non-banking transfer scheme of securities business, would be voluntary. So the three are insurance, banking, and funds. The new rules permit non-mandatory transfer schemes to be effected by client consent, assignment under the relevant terms of business, and with the consent of the DFSA. The present transfer scheme does not fall under that chapter. Importantly, the changes to the Part 9 regime, which were introduced in February 2015, were consulted on a miscellaneous consultation paper by the DFSA. The consultation page ran to just over 1 page. It contained very little detail and no benchmarking. The DFSA also very recently published guidance in its regulatory policy and process sourcebook. This is a form of non-binding guidance which sets out the DFSA's policy and process on various matters. You can find that at page 1 of the DFSA bundle. I don't propose at this stage to read through that. I mention it merely because technically it now forms part of the overall Part 9 regime of the DIC. But I'll come back to this issue of the history of the Part 9 regime shortly, but I think it's worthwhile mentioning at this stage that the DIC appears to be the only jurisdiction that we were able to find which mandates a banking transfer scheme. I noted a moment ago that the DIC regime effectively copied UK FSMA Part 7, and as I also mentioned, in the UK, only insurance transfer schemes require court approval. Now, my learned friend from the DFSA, Mr. Lake, may seek to persuade you the reason the DIC has such an unusually strict regime for financial services business transfers is because of the special nature of the DIC banking sector and the DIC itself. And however, while the DIC banking regime is special, it's not for reasons which we would submit require these additional safeguards and protections for banking customers. What is unique about the DIC banking regime is that it is an entirely non-retail regime. Banks in the DIC cannot accept deposits from persons who are defined as retail customers. This means, and this is quite important in terms of how the court should assess the risks connected with this matter, this means that all DIC depositors in any DIC bank are professional clients. Therefore, they're either high net worth individuals who have to pass a certain qualitative and quantitative test to be classified as such, or they're institutional customers like companies, other banks. These are the sort of sophisticated customers who are likely to understand the negligible risks associated with the transfer of their bank account in our submission. Now, Your Honour, I propose for the purpose of the applicant's submission to cover 4 key areas in responding to the DFSA's submissions on the issue of Part 31. Would Your Honour like me to take you to the relevant portions of the DFSA skeleton? If I could take Your Honour to page 9 of the DFSA skeleton, and you'll see under Roman number 4, Roman numeral 4, other issues, the DFSA set out its submissions from paragraph 30 on this particular matter, 30 to 41. The DFSA essentially submits that, or first of all, it sets out what the background is to Article 111. And it sets out its key policy considerations, which are that it wants to ensure that the scheme report provider has the requisite professional experience, expertise, and skills to provide the scheme report, to ensure the scheme report is in a proper form. It then states that this requires a specialist person with the relevant attributes, and they note that Clifford Chance, that the DFSA agreed to the appointment of Clifford Chance as the provider of the scheme report on the basis that any conflicts of interest would be managed appropriately. And this is an important part, that the statutory requirements in Part 9 of the regulatory law are satisfied.
And then in paragraph 35, they state that a proper report was included as an obligation for the scheme report provider to be an expert, or if not,
Yeah, this is a point I was proposing to make submissions on, Your Honour, because the DFSA seems to be submitting that for the report to be proper, there should be an obligation that the report provider is either an expert, and I would assume that means an expert generally, an expert in his field, a skilled person, or if not, independent and neutral in carrying out his assessment of the relevant transfers. Now, it seems to me that there appear to be alternative routes the DFSA is proposing in this regard. Now, this is a little confused because, on the one hand, the DFSA is submitting that the scheme report provider must be a Part 31 expert, but there's clearly is making submissions that in the alternative it can be an independent and neutral. And I'll leave it to my learned friend Mr. Lake to make submissions on that point, because
the DFSA indicated that Clifford Chance to be provider. Well, if they indicate that, does that imply an acceptance that Clifford Chance answer these requirements, that they're either expert or they're independent?
I think the DFSA, and I can't speak for the DFSA has said that they broadly accept that Clifford Chance would have the skills necessary to provide the report. What one would have to assume is because Clifford Chance is an international law firm, we have offices in Dubai and Singapore, which are two relevant jurisdictions, and we are experts in banking sector mergers and acquisitions activities. Those attributes are not found in every law firm based in the DIC. So I think I can safely say that the DFSA is content that Clifford Chance has the necessary skills to produce a rule, but it is also saying that subject to the Clifford Chance dealing with any conflicts of interest that might arise, because Clifford Chance also acts as transaction counsel for the applicant. However, the submissions at paragraph 5, which you permit, Your Honour, also seem to indicate that if you don't have the requisite level of skills, in other words, you're not an expert, the DFSA might be content if you're simply independent and neutral. It seems to contradict the regulatory law requirement, which is that the person must have the skills. I suspect this is simply a typo. Perhaps they meant and instead of or.
Sorry. Yes, sir.
In the second sentence, while the regulatory law is silent on what is a proper report, DFSA considers this includes an obligation for the scheme report provider to be an expert, or, if not, to be independent and neutral. Now, it suggests that perhaps the or would be the and.
Well, I think by virtue of being an expert, they would be independent and neutral. In this particular application, application for business transfer. We recognise that Clifford Chance does have the necessary skills for the purposes of opining on the scheme, but our concern relates to their degree of independence and neutrality, given that they are the advisors to the transferor in this matter.
Well, those concerns you can answer. I understood from one of my just there's the DFA accepted that Chance can be provided, as long as the report answers the other requirements that you say have to be answered.
That's correct, yes. We have accepted Clifford Chance, providing that the basis on which the report is provided is a proper report as required under Article 111 of the regulatory law, and it addresses the concerns the DFSA has regarding the potential conflicts of interest which may arise from the scheme report provider's position as advisor to the transferor, and also the duty it owes to the court to give an assessment of the impact.
As to how Clifford Chance are going to model themselves so as to ensure that there is no conflict of interest.
Forgive me, Your Honour. That's correct, yes. There was I understand there have been discussions regarding the separation of the legal advisor role, and there was...
Is there any sort of sign-up protocol or anything of that nature?
No, I think at the later stage that there's a negotiation around the limitations and the reservations within the draft of the scheme report regarding the role of Clifford Chance and the separation of the two functions. But I'm not aware of the latest what the position that's been agreed. Forgive me.
Your Honour, if I may.
Thank you, Your Honour. I understand that it's been the DFSA has indicated that they would require there to be a separate team within Clifford Chance between those that are advising on the day-to-day advisors on the transfer, which is separate from the team which will be providing the opinion as set out in the scheme report. And the DFSA had asked the applicant to provide the names of those two separate teams to ensure that separation, but that has not come forward. And I think all we've seen so far is the latest draft of the scheme report, which indicates there is still one team involved in providing the report and advising on the transaction.
If the team comes to consist of those who are not involved or and are not involved in the transfer, then that would be sufficient for the DFSA. Or would you want further aspects of trying to
No, Your Honour, I think that the first proposal will be sufficient for the DFSA's concerns.
Thank you very much.
Sorry, if I may, Your Honour, I've just been handed up by those instructing me a correspondence by email on the 8th of February, the 9th of February, from a Mr. Ken Cogwell of the DFSA from the supervision team. It's addressed to the applicant, and in that, dealing with the issue of independence. And I apologise, I don't believe this email appears in the bundle. Is it? Okay. It's a the supplemental bundle. It's tab 7. Yeah, so a supplemental bundle which we've handed up to you. Yes, and it's at page 93, tab 7. If I could direct Your Honour to item 3, right? Paragraph 3 of that email starts with Dear Grant.
Yes.
It says, on the issue of independence, we are assuming Clifford Chance has appropriately addressed any conflict of interest issues. To the extent they do exist, these should be disclosed to the court and DFSA, noting Clifford Chance has a duty not to mislead the court. As far as we're aware, there have not been substantive discussions on this issue. Of course, the applicants would be happy to have substantive discussions, but depending on the outcome of this directions hearing, they may not be entirely necessary. Because to some extent, Your Honour submitted that the form of the scheme report which is to be provided is largely factual. Those who are in the best position to understand how the scheme will operate are in fact those who are advising the applicant on the actual transaction itself. Obviously that information can be provided to a person who's independent from the transaction so that they can produce a report independently. However, there will need to be some input from parts of Clifford Chance who are in fact directly involved in the transaction.
As providers of fact.
As providers of fact. But ultimately, this would have to be some form of compromise, if agreed with the DFSA, because Clifford Chance acts as a whole. It's one law firm. So the concept of Chinese walls, whilst helping to mitigate conflicts, we could not ever remove them entirely. Hence, perhaps, why the DFSA said to the extent that conflicts do exist, these should be simply disclosed to the court and to the DFSA.
Well, can you help me with this specific? Is it feasible that Clifford Chance to establish a team that would have primary responsibility for producing this report, the members of which would have had and do have no involvement in the transfer, accept that those involved in the transfer could be providers of information or officers who just simply object to facts? Is that feasible?
In principle, subject to instructions, that's certainly feasible.
Right. Well, thank you very much. You go on.
Well, the remainder of the DFSA's submissions, I propose to address in my submission. So, with your permission, Your Honour, if I could briefly touch on one particular aspect of the Part 9, which is relevant, again, as a threshold issue.
Yes.
Has Your Honour had the opportunity to read Article 111 of the Regulatory Law, Part 9?
Yes.
Okay. If I could take you to tab 6 of the application bundle, Your Honour, it's at page 22.
Yes, Article 111.
Article 111, subsection 1 of the Regulatory Law states that an application under Article 108 in respect of a scheme shall be accompanied by a report on the terms of the transfer scheme, and it defines it as a scheme report. The scheme report may only be made by a person appearing to the DFSA to have the skills necessary to enable him to make a proper report, and the relevant scheme report provider must be nominated or approved for the purpose by the DFSA. And it says that a scheme report must be made in a form approved by the DFSA. Under subsection 4, the DFSA may by written notice direct that the scheme report need not be provided in cases of urgency, but only if it's in the interest of the DIC to do so. In the one previous transfer scheme that was before this court, the DFSA agreed to waive the requirement for a scheme report. And instead of a scheme report, the applicant provided a witness statement on behalf of the applicant, setting out, broadly speaking, the terms of that particular transfer. Now, we know that under subsection 2A, the person making the report must have the necessary skills to make a proper report. In other words, the person must appear to the DFSA to be a skilled person. However, whether that person is referred to as an expert or a specialist or some other word is neither here nor there. However, under subsection 8, the court may not determine an application if the applicant or the firm concerned have failed to comply with the requirements in Article 111. Now, one of these requirements is to provide a scheme report, unless, of course, the DFSA dispenses with that requirement. It is not disputed that the purpose of that report must be, at least in part, to inform the court of the terms of the proposed transaction, because the court is required to sanction or not sanction the relevant transfer scheme. However, the law is completely silent on the purpose of the scheme report. And the law also contemplates a situation where the DFSA waives a requirement, so in certain circumstances, such as in the one previous Part 9 transfer, the report can also be made without any form of report other than some alternative form of report. And it's clear that as long as an application under Article 108 of Part 9 is accompanied by a scheme report, unless waived, this would satisfy the requirements of Article 111.1. Now, I mention this because there is no specific requirement under Part 9 for the person producing the report to be an expert, to be independent, to be appointed by the court as an expert. Therefore, this issue must, if it's submitted, be a matter of discretion for the court.
You just showed me the requirements of Article 111 that require the maker of the report to have the skills necessary. Your position is that in fact that isn't necessary.
It's not necessarily. This is, I think it would no doubt help, and as a matter of regulatory policy, I could understand why the DFSA might wish the person to be independent, and indeed, more importantly, why the court might wish the person to be independent. But,
you're on the independent side.
well,
that the person making the report must have the skills necessary to make a proper report.
yeah, absolutely.
What you're doing is the requirement of independence.
Yes, it simply isn't one. Whilst it may be desirable from a policy perspective, and the court may, in fact, wish the person to have sufficient independence for the purposes of making a report which will be used by the court, however, the law is silent. So this is submitted would be a matter of discretion for the court. Under Part 9, the only aspects of Part 9 which impose any kind of condition on the court are found on page 23. That's Article 112, and which is that the court, before it makes an order sanctioning a transfer scheme, must be satisfied that the relevant that the transferee has the relevant authorizations required to accept the business. In other words, if a bank is transferring to another body, that other body must also be a bank as well. And also that it has adequate financial resources in accordance with the relevant legislation applying to that person. Clearly, the regime is designed so that if there's a transfer, a skilled person is provided a report. The key aspects for the court to consider in granting sanction for the transfer scheme are that the person has the relevant licenses and they have adequate financial resources. And no doubt one can see the very good policy reasons why the regime is designed this way, to protect customers, to ensure when their business is transferred, the relevant transferee accepting that business is properly licensed and is sold. And that's simply the background to the...
The conditions articulated in Article 112 are exhaustively stated. And therefore, so long as those two conditions are satisfied, that's it.
As long as the applicant or the firm concerned has complied with Article 111, so provided a report and made notification to the newspaper and to interested parties, the court can then, the matter can progress, and the court can then consider whether to sanction the transfer scheme, and the conditions for sanctioning that transfer scheme must be met, which are those conditions set out in Article 112. But they're not necessarily exhaustive. There may be issues when the court is considering the scheme report or the matter generally, where it may seek guidance from the regulator as to certain aspects of the scheme which it maybe has concerns with. But strictly speaking, under the law, the key conditions for a transfer to take effect are set out in Article 112.
Well, at the moment, the court has an overall discretion, and it will exercise that discretion, having regard to the overall context of a particular transfer, and as to the underlying purposes of the regulations and the function of the regulator. And I think that it would ordinarily be a matter of concern whether the maker of, in other words, the entity or individual who is responsible for drawing together everything that has to go into it, is independent of the transfer. These days, transparency is important in many areas where in the past those considerations didn't have the importance that they now do. And I'm inclined to be, although I appreciate the only in the stage of argument, I'm inclined to the Clifton Township had a team who is responsible for the production, none of whom were involved in the transfer, but that the scheme can receive factual information from those who were, and that that factual information should be produced in a memorandum, a little bit like agreed facts for a particular hearing, which could be provided to the DSA so that they can see what the factual input is. And if it is indeed purely factual, it seems to me the DSA would have no proper objection to that.
I'm grateful, Your Honour. And I propose to address some of these issues, in particular the context around of this particular transfer scheme, because as Your Honour rightly points out, is the context and the risks associated which are relevant to the court exercising its discretion in deciding whether or not to require the scheme report provider to be a Part 31 expert. Now,
Private having the expertise and experience who are set to assemble a report that complies with the regulations. So if someone who's selling legislation below the store in the market is unlikely to have the necessary skills to be a report, but a professional of the like of lawyers employed by chance would certainly have faced the
subject to instructions and subject to the views of our General Counsel, I would submit, Your Honour, that in principle the Clifford Chance could accept that. Your Honour, we'll do our best to get you an answer as quickly as possible. However, the applicant admits that although the issue of independence is clearly important, and the court has also made this particular point, the question still remains as to whether or not the scheme report provider must act as an expert for the purposes of Part 31 of the court rules. And this is a critical question, and one I propose to make submissions on, unless, of course, Your Honour doesn't propose to require.
What it means is regulatory the provider must have the experience and skills necessary to appreciate what the issues are that have to be covered, both to inform the court properly and to implement the regulations, and have experience in the process of producing documents of this nature. Now, lawyers are sort of employed by who have had a few years experience in which are particularly to have that experience within the team. You'll have to have some one or two who have experience in banking or regulatory matters, but who have to be involved in the transfer. So that, I think, is what is meant by expert. It is in context of this particular application, probably more generally. So what I'm saying to you is that you can assemble a team doesn't include anyone who is involved in the transfer, but does include lawyers with decent experience in banking and the regulation of financial services. Then you'll satisfy the requirements of Article 11 to that extent.
I'm grateful, Your Honour.
Well, I'm going to get Mr. Lake, but I need help with give us a running commentary on why horses they are afloat.
But if your permission, Your Honour, could I though address one final point, which is crucial to this particular matter? I think in principle the Clifford Chance would be happy to work on the basis that you propose. However, the key issues really, and this can be found in the correspondence between the DFSA and the applicant, is the question of whether Part 31 of the court rules applies, because the issue that arises there is should that apply, and should the scheme report provider, whether it be Clifford Chance or any other person, be held out as being an expert for the purposes of the hearing, for the purposes of the transfer scheme, then this raises certain risks under the penal code that which could expose the expert report provider to imprisonment. Therefore, this has been a source of ongoing discussions between the DFSA and the applicant. And the applicant was led to believe that the descriptor on the issue of whether the scheme report provider should be expressed to be an expert was agreed, in fact, by correspondence between the regulator, senior management team of the regulator, and the applicant, and subsequently by correspondence between the supervisory team at the DFSA and the applicant. The applicant was led to believe that the name expert would not need to be appended to the report provider, for the very reason that this would avoid the penal code risks under Article 257 of the Penal Code. However, within a few days of the DFSA confirming that the scheme report provider would not need to use the term expert, the DFSA, for want of a better word, backtracked and said that the question of whether Part 31 should apply is a matter for the court, and that the applicant should make submissions on that point. Naturally, because the law is absolutely silent as to whether the scheme report provider must be an expert under the court rules, the applicant did not propose to seek directions on that point, and therefore the DFSA felt compelled to seek its own directions. Would it assist, Your Honour, if I took you to the relevant part of Article 257 of the Penal Code, so we can...
Well, I think also the rule of court.
Absolutely. So, which particular rule is Your Honour referring to?
Then there would be consequences that could lead into criminal liability.
Your Honour, it's more, the way that this needs to be approached is that it's more a question of how the scheme report provider is described for the purposes of the provision of that report. If the scheme report provider is expressly provided to be an expert, then potentially that person falls within the remit of Article 257 of the Penal Code, and therefore this raises some risk of imprisonment should
Let's see the provision.
Your Honour, if I could take you to page 6 of the DFSA bundle. Yes, this is part of the DFSA submission. It's a tab B. Tab B.
Which article is it?
257. Your Honour, contrary to the DFSA's submissions in paragraph 39 of the skeleton, it's submitted by the applicant that Article 257 does create a risk for a party acting as a Part 31 expert. In essence, under Article 257, and I'll paraphrase it so that by just referring to the role of an expert, that it states that any person who submits a report failing to maintain the requirements of integrity and impartiality in his capacity as an expert, appointed by administrative or judicial authority or selected by the parties, shall be sentenced to temporary imprisonment. Now, it's submitted that Article 257 potentially applies in the present context because the scheme report provider would provide a report and they would be doing so having been selected by one of the parties, and therefore this brings the scheme report provider into the sight, as it were, of this particular provision. So it is clear that this provision is intended to deal with cases of alleged bias. However, contrary to the DFSA submissions, there is nothing in there that indicates, other than tangentially, that it would apply to bribery and corruption. This is the speculation. It does, however, apply to cases of alleged dishonesty. So issues of integrity and bias, and not what concerns the applicant. The real issue, and one which the DFSA fairly summarily dismisses in paragraph 40 of its skeleton, is that the risk of an unhappy client, who is part of the proposed transfer scheme, making a complaint to the police, and this could potentially lead to imprisonment of an employee of the scheme report provider. But the DFSA submits at paragraph 40 that no person can prevent such claims being made. This is absolutely correct, Your Honour. However, this is not a good reason for the scheme report provider to accept the risk associated with Article 257. Quite the contrary. The applicant would submit this is exactly why the risk exists, because such claims cannot be prevented. Simply put, it's a risk of arrest and not a risk of conviction. And the question that arises as to why that is. And the applicant would submit that it is not uncommon in the UAE for those persons who are subject to a complaint to the police to be imprisoned awaiting trial on the underlying criminal allegations. And this could be potentially used as leverage by the complainant. It is, Your Honour, it is fair use. Well, it's common knowledge, Your Honour, that because of Article 257, many arbitrators in the UAE are no longer acting in hearings, and that steps are actually being taken by leading UAE lawyers to get this provision amended. So if I could put it this way, it's the effect of this provision is that it seems to put the arbitration industry on hold for now. So while the DFSA would have you believe that the applicant is seeking to disapply Part 31, and that this is a flawed argument because of Article 257, the applicant submits that the risk is real. And it's submitted that this risk should be taken into consideration by the court in deciding whether to exercise its discretion to require the scheme report provider to be a Part 31 expert. Your Honour, it wouldn't require the court to disapply 111. 111 simply requires that a report is produced by a skilled person. And that report, as the court pointed out, preferably should be independent. However, Article 111 does not require the person submitting that report to be a Part 31 expert, just a skilled person. So this is the key issue, and this is the threshold issue, because largely, if Clifford Chance, or indeed any other scheme report provider, is required to be a Part 31 expert, and therefore expressly required to be an expert, it's submitted that certainly Clifford Chance will not act as a scheme report provider, and neither will, in our submission, any other relevant. And this point has been addressed with the DFSA at some length. However, the DFSA is persisting appeals, despite previously agreeing that the report provider would not need to be an expert. They're now persisting on this point. And Your Honour, the applicant submits that this must be something at the front of the mind of the court when it's deciding whether or not Part 31 should apply. Typically. Yes, but Your Honour, there's no requirement that the person need fall under Part 31 of the DIA rules. There's no. Your Honour, if I could, do you have a copy of the court rules? That's correct, Your Honour. However, reading more broadly within Part 31, it appears to be experts for the purposes of litigation. If I could take Your Honour to 31.5, states that expert evidence should be the independent product of the expert, uninfluenced by the pressures of litigation. In the present matter, this could not reasonably be described as litigation. This is merely an order being sought for the sanctioning of the transfer scheme. There are no opposing parties, as it were. It's submitted by the applicant that the context of Part 31 is really for the purposes of litigation, where competing parties require an independent expert to opine on a particular matter. In this case, Article 111 of the regulatory law simply states that a transfer scheme must be accompanied by a scheme report prepared by a skilled person.
Yes, but the really relevant provision is Article 257, not this rule. Whether or not you fall within Article 257 depends on the meaning to be given to Article 257, not on whether or not you fall within Rule 31.
That's correct, Your Honour. For the reasons already given, the applicant admits that that acting as an expert, expressly acting as an expert under Part 31 of the court rules would always bring a person under Article 257. Yeah. That's correct. That's correct, John. Which is why the applicant seeks the court's discretion not to require the report provided for the purposes of the transfer scheme to contain any references to it being provided for the purposes of Part 31. The applicant, the scheme report provider, will no doubt be happy to have the necessary skills and to act in an independent manner. The key question is whether or not they can act as an expert under Part 31. If they don't, then 257 doesn't apply, and therefore this scheme can proceed. Otherwise, it's submitted. This Part 9 regime is rather frustrating. That's correct, Your Honour. In other words, the applicant would submit his preference is for the court not to make any direction on this point, and that the applicant and the DFSA can agree to the right wording such that the applicant is described as a skilled person and not as an expert, which is the language of Part 9 of the regulatory law.
There will still be some residualness
would the court be...
What the court could do would be to indicate that if the parties agree that the making of a report is not described within the report, and that the ASA are content that it's sufficient that you're skilled, but don't treat you as qualified. And I think the court in the knowledge of that being accepted by both sides, the court would go along with that and wouldn't make any difficulties or interfere with that consensus. But I want to emphasize that such cooperation cannot constitute a guarantee that 257 will be applied against it.
I'm grateful, Your Honour, and the applicant and to the Chancellor are aware that there's still some residual risk of some other person deciding that to the Chancellor was acting as expert, and that risk cannot be eliminated entirely. However, would the court, or would Your Honour be, in terms of your cooperation, as you described it, would Your Honour be content for the scheme report provider, and whether that be for the Chancellor or some other person, to include within the scheme report just a bare statement that the report is not provided for the purposes of Part 31 of the DI support rules?
Well,
it's simply a statement of fact.
Just give me a moment. I'm having a discussion because I should be regarded here as the next final stage of this process. Difficult for me to find another one that would use the last expression. All that can be avoided if I also hear the application for approval, which would be the normal sensible course, and I'm just checking about the court arrangements for that. I think it's going to be approached.
But, Your Honour, if it may assist the court, my understanding is that the provisional listing of the hearing, of the further application, which is the application for approval, is listed for the 9th of April 2017, as you may be aware, which is, we understand the date at which, according to the diaries, you're likely to be in the DIFC.
I think that's probably okay. I'm going to have to just take it up. Is there a little bit of flexibility on the party side as to the 9th of April?
The key date for the applicant is the 30th of April. This is the intended effective date of the transfer scheme. If it assists the court, the transfer of the applicants in private banking business is actually occurring in 3 jurisdictions. I believe the DIC is the smallest part of the overall transaction. The transaction is occurring simultaneously in Hong Kong, Singapore, and Dubai. Now, in Hong Kong and Singapore, like most jurisdictions, banking transfer schemes do not require court approval. And the date set for the transaction to be effective is the 30th of April. So the timetable is most squeezed for DIC. However, depending on the ability of and the agreement with the DFSA to various notices being issued, and the timeline for issuing those, it may be that the hearing could be slightly earlier, or perhaps in the week or so following. That's correct. As long as, of course, the applicant and the DFSA can agree to the relevant timetable for issuing various notices under Article 111. There are 2 notices required, one in the newspaper.
Well, I think the statement you introduced is that the court would be content if the parties can agree by parties under the DLSA and the transfer or scope of the chance can agree that you're not described. The nature of this report is not described as an expert and does not fall within the rule of 31. I think it doesn't fall within the rule of 31 because there's no litigation. That's the point of the data. So that there are no red flags in the report suggesting acting as a vet. And it being understood that there is a requirement of skill, I've indicated what I think that means. The court would have no difficulty in that situation if this can be settled between the DFSA and yourself. In other words, I'm satisfied that if you produce if you deal with the conflict of interest in the way that I said that and you provide the names of who are in the team, just a sentence or 2 of their experience in the banking and regulatory market, then that could lead to the court's acceptance that the making of the report is still to the purposes of Article 111. So we'll have to wait and see what emerges as discussions between the judge and the DFSA.
I'm grateful, Your Honour. If I may, though, on that, the issue of the negative statement being contained in the scheme report, stating that it is not a report produced for the purposes of Part 31 of the court rules, would Your Honour be willing to accept a report which contains such a statement? This would be helpful for Clifford Chance in persuading its General Counsel. The wording would be along the lines of, this report has not been produced for the purposes of Part 31 of the DIC court rules. It's simply a statement setting as a negative statement, in other words, making it clear to anyone reading it.
Yes, I can go along.
Grateful. Is there anything else, Your Honour, that we can assist you with at this point?
I'm grateful, Your Honour. I'm particularly grateful to the court for making so many points, which I intended to make in my submission. First, dealing with the the latest point that's been raised by my learned friend. Would it help if I take Your Honour to the section of the draft scheme report we've currently seen, which contains the specific wording regarding it's in tab C of the respondents manual, which will be a red folder, Your Honour. Behind tab number 1. At page 18. To give you the context for this exhibit, Your Honour, this is an exhibit to a witness statement from a member of the DFSA supervision team that is responsible for the relationship management with the transfer of the applicant. And these pages are extracts from the draft of the scheme report which the DFSA received a little over a week ago. It's over 100 pages in length, so these are just the relevant extracts which we thought the court would find of assistance for the purpose of these proceedings. So on page 18, paragraphs 1.1 and 1.2 deal with the limitations and the purposes for which the report is provided. I'll give Your Honour a moment to read that. The offending part, if I may call it that, is in the last sentence of paragraph 1.1, where it refers to in parents report under Article 111.2 of the Regulation Law, Clifford Chance is not and does not purport to be acting either as an expert or an independent expert in connection with the report. Neither Part 31, experts and assessors of the DRC court rules, nor Article 257 of the UAE Penal Code applies to Clifford Chance in connection with this report. As Your Honour rightly points out, it's not really for the court, or DFSA, nor for Clifford Chance, to assert the extent to which Article 257 does not apply. So we would say that simply cannot remain within the report. But we would be content to, with regard to the issue concerning Part 31, we thought that was a matter on which the court would wish to form a view as the extent to which it applies.
I'm content that this doesn't Part 31, so that can be stated. But I think there ought to be a sentence here that says that the representatives of Clifford Chance producing this report had no involvement in the transfer.
Your Honour, might I suggest actually that the effect of Your Honour's proposed wording will be dealt with in paragraph 1.3 at page 12 of the same exhibit you have open. So if you go forwards in the bundle a few pages, page 12, that's correct, headed introduction, with reference to paragraph 1.3, which sets out the role of Clifford Chance.
Yeah,
I'm grateful. And we can come to some agreement on the appropriate wording regarding the limitations in paragraph 1.1.
well, at the moment, the words from nor Article 257 to the end of the sentence of the file. But I don't, at the moment, see that other than questions of the style tidying up, I don't see that there are any necessary changes.
Grateful. I'm not sure to what extent I need to address the court further on the issue of the expert, other than to say that perhaps the confusion or concern appears to be it's related to the attachment of a label as expert. The GFC agrees that label ought not be attached to Clifford Chance in this role, but we do recognise the requirement for Clifford Chance to have the necessary expertise in compiling the report. And I think there's indeed, right, that's much better.
So you do agree with a number of Clifford Chance with a view to clearing the way of
That's correct, yes. We do, in fact, have some draft wording, which
well, then that's a threshold issue. There are a number of other issues. Should we take confidentiality at this point? That seems to be another rule.
I am, Your Honour. I'm happy to deal with confidentiality, and there's a couple of other minor issues. And on confidentiality, I'm going to have to call in part on Mr. Bastani, who's the representative of the transferee, as well. I should perhaps say at the beginning, Your Honour, no doubt you're pleased to hear that we're seeking actually quite a narrow order in relation to confidentiality, not as broad as it appears in the draft order, given subsequent developments. Your Honour will no doubt have noted at paragraph 17 of the DFSA's, paragraph 27 of the DFSA's skeleton, that they recognise that the identity of clients, third parties, counterparties, and their non-public information connected to the transferring business may be confidential, and therefore quite properly ordered by the court to be treated as such. I don't know if I need to take your honour to the relevant rules of the court that are set out at paragraph 9 of my own skeleton. And the rules themselves, if you need them, are actually in tab 10 of the applicant's bundle. Okay. 35, 4.3. So 35.4 is actually in the introduction dealing with a hearing, or any part of it may be in private if 3, it involves confidential information, including information relating to personal financial matters, and publicity would damage that confidentiality. And then subsection 7 also says the court considers this to be necessary in the interest of justice. The introduction of that section is related to the hearing being private. It may also be relevant to look at Article 53 of the DIFC Court Law, which is in tab 7 of the applicant's bundle. At page 31. Which provides the court with a discretion that the DIFC may, at any time during or after the hearing or proceeding, make an order forbidding or restricting the publication of evidence if it is necessary in the interests of justice.
Well, is there any document that's going to form part of the process that you need to approve that will be performed that will identify the names of clients or third parties?
Yes, Your Honour, that's the right question to ask. The intention is that the transfer order will annex the scheme report, and within the scheme report there will be a list of the client accounts that are going to be transferred, not the names, and that was changed from my skeletons. It will just be account numbers. So I'm not sure it's been. Sorry, the scheme document will be annexed to the transfer order. I'm not sure that's been discussed with the DFSA, but we're not now asking for the identity of client names to be made confidential because there won't be client names in that document. There'll be a list of account numbers, and it's been done before in the RBS scheme in England, for example. So we're not asking for confidentiality in relation to that, assuming that that's acceptable to the DFSA to have a list of the relevant account numbers only. The one area where there may be some confidential information is that there's also intended to be a list of third-party agreements between the applicant and what are called introducers. They're introducer-type agreements, whereby the introducers have an agreement with the applicant to introduce business to the applicant. And some of these introducers are individuals. They're third parties. I understand there are approximately 25 or so of these agreements that will be transferred as part of the scheme as they are used exclusively by the applicant in the business being transferred. These agreements are governed by DIFC law. The third parties concerned will of course be given notice under Article 1115 of the regulatory law. I'm not sure the idea is an innovation. Just take instruction. I mean, the purpose of the transfer order will be to transfer those agreements rather than to novate them, but they will be notified of the hearing, of course. It occurs automatically under Part 9. So the transfer order itself takes the place of an ovation.
And then it will be for the third party to decide whether they want to perform his introductory role and transferring the business.
That's correct. That's correct. And the intention is, it's quite simple, is to have a list of these agreements attached in the scheme report, not the agreements themselves. And they would simply, and there's about 25 of them, and they would simply state something along the lines of agreement dated, and then insert a date, because you have to identify the agreement, between the applicant, ABN AMRO, and party, and then I would suggest something like number 1, number 2, number 3, number 4, number 5, rather than the name of the third party. That's what's being proposed in terms of very, very limited confidentiality here.
Is there any coding within the books of the transfer law that could be deployed? You told me about numbers which are going to keep applied, so that presumably just comes out of the...
That's account numbers.
Yeah, that's account.
Yeah.
Are there any similar sorts of insignia assigned to these third parties that could be used so that they could ultimately be identified by going to your books rather than just 1, 2, 3, 4?
Unfortunately, I'm informed no. I mean, I can try and think of a more imaginative identification, Your Honour, but...
I think it's identified. I think in those circumstances, the document before the court will have to have their names, but it can be seen. And no reference may be made to the names in the proceedings. But if some other sort of proceedings, that might be necessary, the court would be asked to go to the account, and the court will agree to go to the account.
grateful, Your Honour. And just to be clear, that those documents, to the extent that they're sealed, I presume they won't be accessible by a member of the public without the permission of the court. I'm grateful, Your Honour. The third item in relation to confidentiality is information to be provided by the transferee, and that, if Your Honour perhaps turns to the schedule, which is at tab 3 of the applicant's bundle. Page 9. Paragraph 10, 10A and B. So the applicant proposes to provide evidence in support of the satisfaction of the requirements set out in 8B above, and 8B sets out the Article 1112 regulatory law requirements that my colleague Mr. Shannon took you to through a witness statement provided by an appropriate officer of the transferee, confirming, and the DFSA you've seen from the skeleton has a couple of points on these issues which Mr. Bastani can address you on. Those two requirements, and then if we turn to page, over the page, page 10, at paragraph 13, the order that is sought in relation to that information is at paragraph 13B. Any financial information relating to the scope of licences, authorisations, approvals and exemptions held by the transferee, which is not publicly available, and which is referred to in any documents in connection with a transfer scheme or the witness statement referred to in paragraph 10 above, as this will include confidential financial data and or regulatory information of the transferee, which is commercially sensitive and which the applicant understands the transferee does not wish to disclose to its competitors, or which may be subject to confidentiality obligations under applicable law and regulation. And you will have seen from the DFSA skeleton that they have asked for further details in relation to that, and it may be appropriate at this juncture to ask Mr. Bastani to address you. Perhaps. Mr. Bastani. We can move across the page.
Thank you, Your Honour. Mazen Bustani, Baker McKenzie. I represent the transferee in these proceedings. So, in relation the Lebanese bar, Beirut. Thank you. Thank you very much, Your Honour. So, Your Honour, in relation to confidential authorization, more particularly, in Singapore there are some licenses that are public, but other authorizations that are strictly confidential and restricted by the Monetary Authority of Singapore to disclose to the public, and the clients are not aware or disclosed those particular authorizations and licenses. And this is in particular the licenses and authorities that we would want to keep confidential. Though this is in particular respect in relation to the DFSA concerns to this particular point. We would have to seek obviously the authorization of the Monetary Authority of Singapore to make these authorizations and licenses public or disclosable to the court. We totally agree, Your Honor. However, I would have to seek the, obviously the instruction of the client, but also the instructions of the Monetary Authority of Singapore, because those documents are not publicly available. Obviously, all public authorizations will be submitted. However, those that are confidential would have to be sought from the mass in Singapore. Understood, Your Honor. Thank you.
So is that for now?
Yes, for now, that's the fact.
Your Honour, I think actually Mr. Bastani was addressing you in relation to the confidential information. The DFSA also, to be fair to the DFSA, had a point in their skeleton, whilst Mr. Bastani is here, in relation to the content of the witness statement to be provided, and it's paragraph 23 of the DFSA witness statement. As Mr. Bastani is here, he might
Yes. So, in this particular respect, Your Honor, the applicant, the transferee is suggesting that a witness statement is made by a senior officer of the transferee it will be most probably either the finance officer or the CEO of the transferee, which is.
The problem is that I'm actually seeing the draft. It's difficult for me to decide whether there ought to be someone with more direct responsibility to the accounting than, say, the CEO.
Yeah.
It may be that the CEO may be the statement, but the documents would have to be given in support. Would have to bear out the statements he's making to the financial standard.
Absolutely, and in this.
My own preference that someone from the company's auditors produced this part.
The difficulty here, Your Honor, with the auditors providing themselves the witness statement is that they are somehow unwilling to provide the court or the FSA with a reliance. What will happen, in fact, is either the CFO or the CEO of the transferee will submit the witness statement supported by a legal opinion from Baker McKenzie Singapore confirming that, and addressed to the transferee, confirming that the transferee has the necessary licenses and authorization to receive the business that is being transferred, and B, a PwC report addressed again to the transferee, ascertaining that the transferee has the necessary capital. Yes. Yeah, there will be a report. However, this report will be in support of the witness statement and will not be addressed directly to the court. Yes. This could be done. Absolutely. Yes. Indeed. Thank you, Your Honor. Thank you.
before I address you on the final matter, I don't know if Mr. Lake wants to address you on any of those points. The final direction, Your Honour, that was sort of it's more of a procedural direction, and perhaps it might be useful to look again back at the schedule to our application in tab 3 of the applicant's bundle at page 9. Page 9. Paragraph 12, and this is dealing with the outline form of the transfer order. And there's a suggested outline there, and that, I understand, is taken from UK precedent. I don't know what the DFSA's position is on this, and I would hope that it's not too controversial. There may need to be some amendments. For example, if you look at paragraph 12, that may need to be amended to take account of Your Honour's direction in relation to confidentiality, for example. Sorry, paragraph, yes, 12b and 12c may need to be amended. But this can be discussed further with the DFSA. It would save the court's time now having to deal with this issue.
I think I can safely leave this in the hands of the Chancellor of the DFSA. If you come upon a point which simply can't agree, and it's necessary to have the court's decision before the final application can be made by me in writing. I can deal with it remotely. But I hope that's an absolutely last resort. You ought to be able to agree these matters as before.
That's noted, Your Honour. I'm very grateful, and noted in relation to it being the last resort. There is one other small matter which I have discussed with my learned friend. What we have described as the newspaper notice requirement. I don't know if I need to take it back to the regulatory law again, but and this is not a big issue. We have suggested that the notification that is required under Article 111(6) of the regulatory law be provided in the College Times in English and Arabic. I don't know if Your Honour is familiar with that publication. It's, as I say, I don't think this is going to be a big point, but it's one of the leading English dailies in the UAE. This is how the College Times describe themselves. I guess they would say that on their own website. With a readership of 450,000, again, according to the College Times website, and it's distributed in the UAE, Bahrain, Oman, Kuwait, Qatar and Saudi Arabia. To be fair to the DFSA, the point raised by the DFSA, in particular at paragraph 20 of their skeleton, is some concern as to whether that is a publication with a sufficiently wide circulation, given that some of the professional clients and other interested parties are outside the UAE. And it's fair to say that there are approximately probably 20 jurisdictions in which the affected clients reside, probably about half of them in the UAE, but others are outside the UAE, not in the USA, but in other parts of the world. And having discussed the matter very briefly with my learned friend, Mr. Lake, before the hearing this morning, I think Mr. Lake will correct me if I'm wrong, the proposal was that in addition to the College Times, a notice be given in the Gulf News, which is one of the other, Your Lordship, Your Honour may be familiar with. And I'm not going to ask you about the third, well, I'm going to mention the third one, but of course, and the Financial Times, to cover those entities who may not be covered by it.
Yes, you are.
And of course, each individual notice is served on each individual file.
That's also correct.
And the clients will have a right to say no thank you. only happen after the transfer. So the transfer is made, and then the client say, thank you very much. Or is the client list a moving feast, which can only be 5 seconds just before the application is made in the final law? Anyone help me with that?
Your Honour, perhaps, yes, I may. The requirement to give written notice to each individual client is an affected parties is set out in Article 111, and indeed the applicant proposes to provide that written notification to the clients. I understand at some point between filing the papers for the further application and the actual hearing of the further application itself. So, and from what we've seen, the draft of the notice to the clients, it does make it abundantly clear that they do have the option at any time to effectively not become part of the transfer, and I understand the means by which they can do so is by contacting their relationship manager at the transfer law, rather than waiting for it to come into effect.
So that means that this client list will be for all, albeit by accountants, will only be finding its very short before the application, because it may have to last over a period of time. But before the final application terminated their relationship with transfer all.
I'm not sure I'm the best place to address you on that one, but
That seems to be the logical.
If I can just take instructions, Your Honour. You're on the list will be as complete as it can be on the 9th of April, but it may be that if that's the date of the provisional hearing, it may be that a client indicates it doesn't apply by the 9th of April. And then between the 9th of April and the date that the transaction completes on the 30th of April, that client may indicate that it does not wish to be transferred, and of course the applicant is not going to force. No. So to that extent, the numbers.
The list will be finally settled for purposes of the application shortly before, in the sense that anyone from whom you've not heard saying they want to come out will be on the list, although it may be that they come off before completion of the transaction. I'll avoid that the way these work, which we believe that they're completed.
That's correct. There was one final matter that's been raised by the DFSA at paragraphs 49 to 51 of their skeleton, and that was the timing of what's been called the second client notice, which is actually the notice that is required under Article 1115 to interested parties. The suggestion from the DFSA is that this notice be given as soon as reasonably possible and not less than 30 days before the hearing of the further application, assuming that the hearing is not tomorrow, is not the 22nd of March, according to your Honour's diary. I mean, the applicant's position is it is intending, in accordance with the chronology attached to the skeleton, to give that notice at least 30 days before the hearing of the further application. The timing does depend on the progress of the scheme report. The date and chronology at the moment is the 7th of March. Now, of course, that may depend on when.
Well, it's either going to be the 9th of April or very, very close to the 9th of April. If it will be late, I think the 9th of April may be also earlier. The court could confirm what the date will be before close of business today.
I'm grateful, Your Honour. On that basis, 30 days notice is fine.
thank you, Your Honour. There are a couple of points on which we would like to address the court. But we are certainly very mindful of the place of the DFSA in this matter, and there are only certain aspects of Part 9 and requirements in relation to a business transfer scheme on which the DFSA is properly placed to comment. So we've discussed the statutory requirements under Article 112 for the court to be satisfied that the transferee has the appropriate authorisations and adequate financial resources. So I'd like to just spend a few moments on that, although recognising that it's not really the DFSA's role to raise any objections to that. It's merely to point out to the court our observations on what's proposed. Can I ask Your Honour to refer to paragraph 21 of the DFSA's skeleton argument, please? The DFSA sets out there the requirements regarding Article 112, and specifically that before the court may make an order for a transfer scheme, it must be satisfied that before the transfer scheme takes effect, the transferee will first have the authorisation required to enable the business to be carried on in the place which is to be transferred to, in this case Singapore. And secondly, the transferee will possess adequate financial resources to carry on the business in accordance with the relevant legislation applicable in Singapore. And we've heard from our friend Mr. Bastani regarding the proposals to demonstrate those requirements to the satisfaction of the court. The DFSA's concern, if I might put it as strongly as that, is that the proposals regarding information in the form of a witness statement must go far enough to demonstrate to the satisfaction of the court at that point in time at which the court is asked to sanction the scheme, that the financial resources will be adequate. Now, I don't think there's any suggestion in the applicant's skeleton argument that the witness statement on behalf of, from the CEO on behalf of the transferee will contain any information from the auditors. So we are. And indeed, we are comforted by that now, Your Honour, but previously I don't think that position had been put forward by the applicant. And with regard to the appropriate authorisations and licences, again, the DFSA would take some comfort if that was supported by appropriate confirmation from the Monetary Authority of Singapore that it is able to carry on the business that's being transferred. Well, I think it's really for the applicant to demonstrate the appropriateness of this authorisation. Well, that would hopefully be sufficient, but we would make that observation that that's really for the court to be satisfied on that. Our concern is perhaps sort of related back to the issue regarding the confidential information and whether this information is proposed to be kept from any parties potentially affected by the transfer scheme, or if this will be made available to them for the purposes of enabling them to take a view on whether they ought to be part of the transfer scheme or whether they ought to exercise their rights.
Well, I think that parties potentially can't be given confidential information. In other words, the full unredacted law ought not to be provided to parties that may potentially be affected in not a right or contrary position. They can apply for the full report, and if necessary, then the short hearing of the court will be making. But I think that in the first instance, such potentially affected parties should only be given the redacted documents, and then if they want to apply for the full report, then they can make an application. In what sort of parties do you have in mind that might want to object to this?
We're not entirely sure, Your Honour. Our concern really relates to the rights of persons who may be or could consider themselves adversely affected by the transfer. They're entitled to be heard under Article 109 of the regulatory law. And our concern is whether that, by keeping certain information confidential, information which we're not exactly aware of what that information is that's proposed to be. Indeed, Your Honour, yes.
Well, there's going to be, is the application itself being advertised?
Yes, Your Honour, yes. Yeah, the date and the location.
That's what I would expect.
Yes, Your Honour.
And it ought to be advertised sometime before the hearing. So that if anyone reads the address and says, well, I don't like this and I want to address the court, then they can approach the court to deal with that and then they may such an approach. Chances are that we are probably going to get such a case. I think that dealing with a very strong risk there are that as long as it's advertised in good time, I think that will allow the possibility of that adversity affected parties to address the court.
I'm grateful, Your Honour, and I think that would indeed satisfy.
Now, sorry, you have to just get to what to
it's only a minor point. It's regarding the form of the draft order as currently put before the court for consideration, which is in the draft order for today, which is in tab 4 of the applicant's file.
capturing the various matters which we need to decide. So you will and Mrs. Rabbit and sort that out. This is the best.
I'm grateful.
Then I'll turn that into a formal order.
And the last point, perhaps, to go back to this question of confidential information, is whether it's proposed for that information regarding the authorisation status of LGT and the financial resources to be contained within the scheme report. Is that? I mean, if so, that would be provided to those persons who are directly affected by the transfer.
Sorry, I think, Your Honour, the intention is we've provided in the witness statement outline information in relation to the authorisations will be provided in the witness statement to be provided by either the CEO or the CFO of the transferee.
Well, those offering the report, those making the report, presumably they make some reference to the witness statements.
Yes, yes, Your Honour, yes.
To the extent that the witness statement and all the exhibit documents contained in relation to that is confidential, just to make sure that they conform to what's been agreed between the parties, form themselves. What we don't want is some last minute hitch where the FSA say, well, we only got this a couple of days ago, and we now think there's a difficulty here. That's the last one. So we do want provision of 12 developed drafts, if not final drafts, to the FSA, for the FSA on a fairly strict timetable to give their response.
That's noted.
Now, I think what you should do, when you're drawing up the draft law, you should agree a timetable. Which will go into the draft law. If you can't hammer it out this afternoon, then never mind. You can hammer it out in the next little while, and then I can sign it off to the
I'm grateful, Your Honour. We will coordinate with the FSA.
Nothing further thank you, Your Honour.
Your Honour, you asked us to come back to you on the what I call the independence point in relation to Clifford Chance. Mr. Shanahan is going to address you on that point.
Your Honour, we're conscious of the fact that you need a response from the applicant today, or from Clifford Chance back today. We are still waiting to hear back from our General Counsel, who does not appear to be available at the moment. The potential issue, and the key issue here, is the question of how Clifford Chance's independence is described. While the Clifford Chance would certainly put in place Chinese walls to ensure that the author or authors of the scheme report are separate from the transaction team, ultimately the conflicts of interest will at best be managed, but not removed entirely. And therefore,
as a single entity, has a conflict of interest.
yes.
But if the report is produced, as I said it should be, by a team whose members were not involved in the transfer, and whose members include people with reasonable experience in banking, regulation, financial services, then the court being aware, in other words, the fact that there is this overall potential conflict of interest is inevitable, because you are a single entity. But the court and the FSA are aware of that, and the court has indicated that any potential problems to that can be resolved if the report is produced in the manner that I've outlined. Now, it would probably be better if you had some separation, some room, operations room for the team that's going to produce the report, and whilst the report is under evaluation, where they are, when they're working on the report. But other than that,
And would the court would accept a general statement in the scheme report describing this residual conflict of interest risk that we are one for net confidence of and this was suggested by the DFSA in the email correspondence, that any conflicts which cannot be entirely dissolved, to use your words, be disclosed simply existing, because the Chinese wall has it's a structural independence, but ultimately, as you noted, Clifford Chance will never be entirely independent, because we are one firm, we have one client, and the duties to that client. So would Your Honour be acceptable to the DFSA agreeing language with the DFSA, which deals with these disclaiming in fact that there remain some conflicts, notwithstanding charges, which is simply a statement of fact regarding the fact that we are.
Well, that has to be a statement that perfect chance were instructed on however, this report is produced by a team, none of the defendants were involved, and I think you could probably say the court has indicated that so long as the team is the it would be acceptable for the court to set the report.
I'm grateful, Your Honour. So,
you don't have a view from your general counsel. Certainly, I suppose this is not right.
just to be clear, because the point of this disclosure is essentially to tell the court what capacity this separate team is acting. Does the court require the scheme report to state categorically that Clifford Chance are independent of the transaction? Because I'm not sure that can be achieved. I'm grateful.
What you want to say is that you, the members of Clifford Chance were on the transfer. However, this report is produced by a team that had nothing to do with the transfer. And the report is what's the right word, issue, offer, or whatever it is. In the light of the indication of the court, that the fact that Clifford Chance has acted on the transaction is no reason why the report can't be accepted as on the report.
I'm very grateful, Your Honour. And one final point. You've asked for some sort of CV or description of the person's skills that might be included. Would Your Honour would accept that these CVs or descriptions of the relevant person or persons producing the report be provided separately to the court? I ask this because, as Your Honour has quite rightly pointed out, one can never completely remove or eliminate the risks posed by Article 257. Therefore, it may help Clifford Chance significantly in terms of persuading our General Counsel if we can not refer to any individuals, because it's the individuals themselves who will be at risk. However, if it's simply a case that the court needs to satisfy itself that the relevant team or person who provides the report is sufficiently skilled, would it be okay for this to be provided separate to the report and not to be contained within the actual report itself?
I think there's got to be at least the leader of the team.
I suspect, Your Honour, this could be a reason why Clifford Chance may not be able to act. Because the Article 257 risk is specifically a risk of arrest. It's not a risk of the firm being arrested. It's about an individual being subject to a complaint. If that individual's name on the report, it makes the complainant's job even easier. So it's submitted respectfully that to eliminate that risk, and I would suggest that any firm acting in the same capacity would have the same issues and considerations and concerns regarding this particular matter. And in order to avoid the risk that no report may be produced, because the applicant and Clifford Chance have contacted other firms to discuss this issue, and And so far, all the firms of similar caliber have all said they couldn't act in the face of this Article 257 risk. Or
well, what about this? That you supply the court to the AFSA. The names and positions of the members of the team and identify the detail. And short CVs are annexed to that, simply appear next to the names. And if the FSA have got any questions, they can raise them with me through correspondence if I have any questions. And then those names will they won't be on the full part of that document, they have to be reserved and the DFSA would be expected not to publish it out, but to typically keep that confidential to themselves, having satisfied themselves that the members of the team fall to the methodology that I indicated with the exception. And so the report just has the name, chart with the chart on the end.
I'm very grateful, Your Honour. Unless there's anything else I can assist the court with.
You're on, yes. So if I may, I mean, there is a... the DFSA is concerned that the risk of Article 257 may be somewhat overplayed here, and it really should only be of concern to any people who envisage having difficulty complying with the obligation to act in an impartial manner and with integrity. So we don't want it to be too much of an obstruction to really allowing this transaction to go through. So I really just make that more as an observation. But also, there is a practical point regarding the actual report, which we've already been provided with, that it's very much substantially complete. So I don't know to what extent it is now possible to assign separate teams to compile a report, bearing in mind the work appears largely to have been done already. I don't know if... again, we haven't received information regarding the authors of the report, and maybe that's something that the applicant can address the court on this stage to see if the proposal will in fact work.
Nor if I may, whilst the report is at an advanced stage in terms of drafting, ultimately, when given a chance, if they're able to create a team to produce this report, what's been provided to date, including the facts which are contained in that report, and Your Honour, you've not had the benefit of seeing the report yet, but it is largely a factual report. This is why, certainly in the UK, for a banking transfer scheme, no such report is required. But the point I'd like to make, Your Honour, is that the person receiving that report in its draft form, whose duty it is to finalise the report, does so in his individual capacity. He's free to change the report, come to different conclusions in the report, and therefore it will be his work product. Whether there's been a draft already in circulation need not affect his ability to act independently behind Chinese laws. So although we note this issue that there's an advanced draft, which there has to be because this transaction is on the tight timetable, we don't consider that this risk will be particularly relevant.
I'm looking to those behind me to give some assurance and that indeed is agreeable. Thank you, Your Honour.
Your Honour, I'm grateful. Nothing more. from the applicant.